Hi Jean, how do I fill out a beneficiary form for multiple heirs?
So what's very important when you fill out a beneficiary form, or if you don't fill out a beneficiary form, then that beneficiary form is going to override your trust and your will. So let's say that you're working with an advisor and they forget to fill out your beneficiary form. So now you have a blank form, but your trust or your will is complete. It won't matter because your beneficiary form is going to override your trust and your will. So if it's blank or it's incorrect or we can't find it, then your asset there that would have bypassed probate is going to go through your estate, which means probate. Florida has a minimum of 3% probate fee to a maximum of 6% probate fee. So let's say you have a $100,000 IRA or a $100,000 annuity and you forget to fill out the beneficiary form, or maybe you filled it out but the company changed names. So there's no new beneficiary form on file. That $100,000 now has to go through your estate, even if it's named in your trust or your will. Your beneficiary form will override that, and that will send it through your estate, which is probate. 6% on $100,000, $6,000, or a minimum of 3%, $3,000, and that's if there's no contestment of your estate. So you want to make sure those beneficiary forms are complete. You want to make sure you have a copy. If desired, you should provide your heirs with a copy, and you should also make sure that if the institution changes names, the bank, the brokers, the insurance company, that you get a new form and fill that out as well. When you're filling out the form, you want to be very, very careful. There's a case in the courts right now where a lady filled out her beneficiary form on a $600,000 IRA. She had 6 daughters. The bank told her to fill a new form out when they changed names. She named all 6 daughters in birth order to own her $600,000 IRA when she passed away. And then she died. Now the bank deemed that only the first daughter listed should receive the $600,000 that had never been taxed before. Think about that, what that would do to her daughter's tax bracket, and if she wanted to be a real jerk, she didn't even have to share with her sisters. The question is, why did that happen? It happened because when the mother filled out the form, she forgot 3 important words: in equal shares. She didn't put percentages, she didn't say in equal shares, and therefore it was deemed that even though she put all 6 daughters under primary beneficiary, that only the first listed was primary and the other 5 were contingent. So make sure your beneficiary form is what your wishes are. Be sure it's filled out correctly and understand that that overrides your trust and your will. Now some people think that when they have a trust, they should name their trust to be beneficiary of their IRA. That's not a good idea. There are some new laws now governed by IRS Publication 590, which cause a problem when you list your trust to be beneficiary of your retirement accounts. That's because your trust does not have a pulse and a birthday. So one of the rules is that your heirs must have a pulse and a birthday or a life expectancy in order to inherit your retirement accounts in the most tax-privileged fashion. If you list your trust and it has no life expectancy, you potentially could cause a lump sum distribution into the trust, which is all taxable at the highest tax rate on anything over $11,350. So you only have to have $11,000 and you're in a 35% tax bracket now because you named your trust to be beneficiary. Your children, on the other hand, would have to earn $379,000 to be in the same tax bracket as a trust gets into at just $11,350. So always fill out your beneficiary form, make sure it's on the current institution's form. Make sure you say in equal shares or use percentages, and be sure to clearly delineate what it is that you want. One other thing to consider, if your children or child that will be benefiting from your assets is married, do you have an in-law outlaw, as I like to call them? You know, one of those ones just waiting around for you to die. If you have somebody like that in your family and you want to make sure they don't get anything, then it has to be written that way on the beneficiary form. For example, You have two children. You have Jack and you have Jill. One of them dies before you and they have children. Let's take Jack. He passes away unexpectedly. Would you want his wife to inherit his share of your estate or your grandkids? Most people, depending on your situation, would want your grandkids to have the money. Even if your daughter-in-law is a nice person and you like her, she could potentially marry someone else, and then your money would end up with a family you never met. So if you want the money that you have in your IRAs, your annuities, your life insurance, those items that have a beneficiary which will override your trust and your will, if you want those to go to your grandkids in the case of your child's untimely death, you have to state that. The way that's written, when you list your children down and you put percentages or equally or n equal shares, right next to that you'll put the words per stirpes. Per, P-E-R, stirpes, new word, S-T-I-R-P-E-S. That is Latin for bloodline. That means your child's share would only pass to their bloodline or your bloodline. Now, people ask me all the time, does that apply to my grandkids if they're adopted? And the answer is yes, as long as it was a legal adoption. So make sure you fill out those beneficiary forms. You'll find assets like IRAs, 401ks, annuities, life insurance that have a beneficiary form in them. You must fill those out. They must be on the current institution's letterhead. They must state your children, either the shares in equal shares or the percentages. If you would want your child's share to go to the grandkids, it must say per stirpes. And now a tip from our smart money bitch.
Who's going to care when you're not there? How about putting an estate plan in place for me?